Legislative priorities. In the state of Washington, we need to adopt a doctrine called continuing jurisdiction so that our Department of Labor and Industries, our Board of Industrial Insurance Appeals, and our higher courts can on occasion allow orders that would otherwise be considered final and binding under a doctrine of res judicata. It can allow those orders to be reconsidered. Now, the standard should be that by a clear preponderance of the evidence, there will be a manifest injustice if the order is not reconsidered. And so what does this all mean? Well, it means that, for example, if somebody has a wage order that issued 2 years ago, and there are people affected by the wage order that had no notice, for example, the children who would have gotten benefits under our workers' compensation laws, but for the errors of their parents maybe didn't understand what was being decided, and therefore they didn't appeal within 60 days from when the order was issued. And then the children are denied benefits, the spouse is denied benefits, maybe something else has happened. That's a manifest injustice toward those people who are interested in the outcome. And if it is that the injured worker can come back in the future and show, wait, clearly I have all the proofs, and therefore we should really consider this. This is what the Industrial Insurance Act intended my benefits to be. They aren't that way. Therefore, I'd like a judge to decide it now, or even the Department of Labor and Industries to decide it now. We should allow that. Who can be against that? Are you against the children? Are you against the injured workers? Do you absolutely so worship judicial efficiency that we're going to just dig into the doctrine of res judicata, which means it's already been decided? Are you going to dig into that doctrine so hard that you're willing to watch as people suffer something that's understood as a manifest injustice? It doesn't have to be that way. And in fact, it doesn't make our system administratively inefficient if that's the standard we elect to adopt as a reform in Washington state. How do we know? Well, because other states have the same allowance within their workers' compensation systems. We can follow in the wise footsteps of some of our sister states, like New York, which has this concept in play. So please join me. Adopt a policy in Washington as a legislative priority that says we are going to give full faith and credit to the promises of the Industrial Insurance Act, and we will step up to prevent manifest injustice. An order that creates manifest injustice can be challenged at any time under continuing jurisdiction. Thank you.